privacy. That is not the kind of privacy we're talking about when we talk about privacy laws. In today's video, as a business lawyer and privacy and technology lawyer, I'm going to be talking to you about some of the key terminology that we come across in the world of privacy and technology law, so that next time you are researching this topic online as an eager business owner and entrepreneur, you can have a little bit better understanding as to what's going on. So in this video, I'm going to be talking about a few privacy and technology terms and concepts. Of course, this is nowhere near an exhaustive list. This is just a little sampler. Depending on the appetite for this video, I can do a longer video, covering more topics, or we can do more short videos as well, covering newer, different topics, so you continue to expand your privacy and technology vocabulary. These terms are not picked in any particular order. Of course, all of these terms are going to come up within the privacy and technology legal sphere, in contracts you might be signing, whether they're privacy policies, terms and conditions, user, agreements, subscriber agreements, member agreements, all of that stuff, data share agreements. You're going to see these terms. You're going to see a lot more than these terms, but these are some of the terms we're going to see. And again, in no particular order, we're going to go over some of those terms today and hopefully equip you with some good vocabulary. If you think there's a term here that you're really burning to learn more about, just leave a comment down below and I'll make sure to cover it in an upcoming video. One term, so starting with the first term, aggregate data. This is a term we see a lot, and what does it mean? For those of you that might have studied business or economics in any way, you'll know that when we're talking aggregate, well, there's some element of a big picture conversation there, right? So it won't be surprising for you to find out that aggregate data is data in the privacy and tech law aspect, is data that speaks to a set of data that has been collected from a multitude of individuals that is stripped of the ability to identify any single individual, right? So if there are three people, A, B, and C, and obviously aggregate data refers most often to sets bigger than those of three, but if there's, for the sake of an example, three people, A, B, and C, one is named, one is named X, Y, and Z, the names don't matter, two are of a certain race, one is of another race, two are in their 30s, one is in their 20s, just keeping it at that tight set of data, then the aggregate information on these users will be, given that two are in their 30s, one is in their 20s, the aggregate will likely reflect that the average user or the average member of this company is in their 30s, right? Just law of averages. If two are of a race and one is of another race, they're going to say that the average user or the bulk of users belong to this specific race or ethnicity, depending on how they're cutting it. Gender wise, if two identify as female, one identifies as male, the aggregate data is going to reveal that the average user is likely to be female. However, males comprise 1/3 of all users, things like that, right? So aggregate data, that's what it means. When you're being, when you are on the consumer side and you're being asked for your consent to be a part of an aggregate data set or aggregate data survey, you can rest assured that it is not going to have you specifically, your metrics specifically are not going to be part of any, company PowerPoint. You are going to be one of many that helps the company understand a big picture, for whatever reason the company wants to understand, or for whatever reason the company wants to use the data for. And that can, that's a whole other conversation, but just as to the definition of aggregate data itself. Personally identifiable information, however, PII, this is a term that is the opposite of aggregate data in a lot of ways. Personally identifiable information, again, you can see how a lot of these terms, they sound buzzwordy, they sound spicy because privacy and tech law is like one of the hottest arenas of law right now, but they're just common sense terms. I mean, when something says personally identifiable, are you not going to guess that it can be somehow linked to you as an individual or you specifically? There's something specific there, right? And there's two words that are giving us that hint. One is the word personal, and the other word is the word identifiable, the ability to say, hey, that's her, or hey, that's him. So personally identifiable information is information that identifies, relates to, describes and is capable with or could reasonably be linked to a specific individual. So that's a very different, if you're on the consumer side, consent that's being asked of you than the consent to be part of an aggregate set of data. And you should watch out for that on the consumer side. And if you're a business running, you know, a certain study or survey or situation like that, you should watch out for that as well, to make sure that you understand what you're asking for, because different legal liabilities fall on you depending on the information you're asking for. The terms opt-in and opt-out are terms we see in the privacy and tech world as well. Generally, these terms are speaking to some sort of consent that is being requested of you by the organization or the business that is collecting your information, running a study, running a survey, whatever the case may be. Different privacy laws. Privacy laws in Canada have been largely governed federally. However, there are provincial nuances within the jurisdiction, so there might be a must-do reason that a company is asking you to opt in or out. Sometimes it might be preference of that company to be really safe with how they are communicating to you. However, usually it's best practice to have that opt-out mechanism, and the websites and the companies or organizations that give you the option to opt out are also most often going to be leading you to some sort of page where you can formally opt out. PIPEDA, P-I-P-E-D-A. PIPEDA is, so just like I mentioned in the previous definition about much of privacy laws being federal in Canada, PIPEDA, I'm just going to read what each of those letters stands for. Personal Information Protection and Electronic Documents Act, which became law in the year 2000. So in terms of a jurisprudence that dates back hundreds of years, something being 24 years old is still considered fairly recent and developing in Canadian jurisprudence. And this is the legislation that governs how Canadian businesses, so this is federal, use and disclose personal information in the course of a commercial business practice. A funny one that I feel like none of us knew what it meant until not none of us, I shouldn't say that as a practitioner, I didn't know what it meant, but most of the general public, I feel like, was asked to accept cookies at one random day in their life. They all said yes, not knowing what cookies were. And so many years after the implementation of cookies on party websites, people still don't know what they are, but we all clicked accept all the time. What are cookies? Cookies are a tracking mechanism. Cookies are small text files stored in a website visitor's browser by that website. So cookies would be relevant to the organization collecting your data, for example, to help see what information you added to your shopping cart. What items did you browse while being on their website? A cookie is a tracking mechanism, like I mentioned, a remembering mechanism for the party whose site you have just visited. There are some websites that implant cookies in a way that can track your activities even after you've left their page, even after you've left that company's website. In addition to seeing what you did on the website and what you do after, of course, the cookies can also track how you got to the website, what login information you used, and all of that. I am not sure who is the, I can research and perhaps post another video, who the genius that decided to use such a friendly word, cookies, for this rather potentially nefarious tracking mechanism was, because cookies are one hell of a just that tracking mechanism, and they serve a variety of purposes and can have quite profound implications on a customer's privacy. So I think we've covered 5 definitions in this video. I'll leave the video at that. Of course, like I mentioned, my goal is to have more of these videos coming up. But if you really, if you really enjoyed the concept, let me know in the comments down below, and I could post a video sooner than later. I want so that next time you see a certain buzzword in a privacy and technology contract, you can Google, privacy and technology terms, or you can Google what do cookies mean, or you can Google what does aggregate data mean, and you come across this video and future videos we're going to put out here on Graphene Business Law, and there's a lot of value add to you. You can better understand not only what you're doing and what you're signing up for, but you can better understand conversation with other practitioners that use these terms, like business lawyers, privacy lawyers, computer science guys, all of that. and have some value add into, you know, how you run your business and your life that way. So thanks again for watching. Please give this video a big thumbs up and click on the subscribe button down below. And our email here at Graphene, our welcome email is info@graphenebusinesslaw.ca. If you're ever looking for a business law firm to help you launch, grow, and protect and conclude your business in Ontario, Canada. And our website, of course, is graphenebusinesslaw.ca. Thank you so much for watching.